Hi, everyone. Welcome to the Immigration Lawyers Podcast, episode number 220. We're doing our regular federal court update for this month with Kevin Gregg, going over November and some slightly December cases just to catch up. But before we start, I want to remind everybody that the Immigration Lawyers Toolbox magazine, issue 3, is out. It's going to be really cool. It is really cool. It's out. If you go to immigrationlawyerstoolbox.com/magazine to check it out. Really big focus on O1 visas, O1As. But issue 1 and 2 are out there, full practice areas. You're going to learn a lot, whether you've been doing this for a week or if you've been doing it for 10, 20 years. Just chock full information. And with some delay, issue number 4 is going to be coming up, general issue. We have probably 20 articles in there, so it's going to be packed. I want to thank the sponsors of the magazine, including Picardo Immigration Paralegals. Picardo, one of our colleagues on the East Coast, started his own paralegal service that has foreign paralegals, primarily in Dominican, that help immigration lawyers, train them. It's a really interesting thing. Just check out Picardo Immigration Paralegals. Talk with them. He's a colleague. He'll fill you in on what's going on to get some good deals on getting that kind of support that your office needs. There's people that are English speakers and are close by, and Spanish speakers as well. I also want to thank our podcast and magazine sponsor, DocuWise, which is the system we all know about. That's for client management, office management, forms, everything all in one. And it just keeps growing with more and more content every day. They just updated the whole system, so it's something to check out. If you want to get 10% off their annual plan, go to go to docwise.com/immigration-lawyers-podcast. Now I say dash, it's supposed to say hyphen. I've learned that for 37 years on this earth, but dash is so much righter when you're saying that. So dash, that short halfway line, that's a hyphen really. But use the code Immigration Lawyers Podcast for that. Also, if you're interested in learning about immigration law, in particular the marriage immigration case, the way I do it, I have a full-on course, 12 hours plus a lot of office hours and hours of stuff to really get you ready to go to be a marriage-based immigration lawyer and grow from there. Consular processing, adjustment of status, disability, all that kind of fun stuff. And you may have heard me talk about the Immigration Lawyers Toolbox library of videos, hundreds of training videos of 1 or 2 minute things, and CLEs, all that kind of stuff. There was a fee for it, but in the new year, I'm just going to go all out and give it free for practicing immigration lawyers. So if you're listening, email me so you'll be on the list to get word of when it comes out. I really have to go back and make sure everything's updated. I've been so focused on the magazine, I haven't updated the video library, make sure the law is good, all that kind of stuff. But it's going to be a growing thing. So just email me, info@immigrationlawyerstoolbox.com, and we'll take it from there. And with that, let's talk to our great colleague, Kevin Gregg. How are you doing today?
I'm doing great, John. How are you?
I'm doing good. I'm feeling much better. It's cold and I keep getting sick or tired, all this kind of stuff. But today was awesome. Woke up at 5 and I'm getting a lot of work out of the way. So what's going on in the federal litigation world?
Well, I'm just trying to get my head around it right now. For the last 2 or 3 hours, I've been deep into the law in effect at the time of one of my clients' grandparents and great-grandparents to see if they were a U.S. citizen in the early 20th century. I mean, it's just going down the rabbit hole. I gotta get my mind out of that because it's just crazy. But no, I'm not talking about any of the citizenship law. I've got 3 things that I was thinking about, and the first, I like to talk about Ninth Circuit stuff because you're in the Ninth Circuit, I'm based in the Ninth Circuit. And it's the stuff going around with the en banc decision from the Ninth Circuit a couple months ago on Asylum v. Barr.
Mm-hmm.
And Asylum came out a couple months ago, but the Ninth Circuit issued Kumar v. Garland. I'm sorry, it was Asylum v. Garland. The Ninth Circuit issued Kumar v. Garland on November 30th. I talked about it on my podcast that dropped this week on Monday. And this is the second decision now applying Asylum. And it seems like adverse credibility is just really, really different in the Ninth Circuit now. The Ninth Circuit held essentially that the law changed under the Real ID Act in 2005, applicable in 2005, such that you can't just base an adverse credibility finding. The court can't affirm an adverse credibility finding based on a single factor. So that is, if an immigration judge in the BIA or USCIS, I guess for that matter, relies on 4 factors, and 3 of those factors aren't good, but one of those factors is good, the Ninth Circuit can't necessarily affirm, and that's because the Ninth Circuit in Asylum said that it's a totality of the circumstances analysis,
Hmm.
which to me, and it's not in all cases, but to me, it means like if you've got three, let's say you get an adverse credibility again for, like in Kumar, there's four reasons for the adverse credibility. And let's say three of them are really strong, but one of them isn't. And you get the Ninth Circuit to agree that that one was not sustainable. That could be grounds for do-over because totality of the circumstances requires all of the factors be considered. And if you take out, and if the board considered four and you take out one, then the totality of circumstances has necessarily changed.
Hmm.
Now, that's a bit of an expansive view of what Alam v. Garland and Kumar v. Garland are saying, but it's not wrong.
Hmm.
We'll see how other panels apply it, but really it's making it a lot easier to challenge adverse credibility findings in the Ninth Circuit. And in Kumar v. Garland, I mean, the immigration judge found that Mr. Kumar's demeanor, for example, indicated he wasn't telling the truth. And the Ninth Circuit affirmed that. It said we can't overturn the IJ on demeanor. But nevertheless, they remanded it because some of the other factors just didn't hold weight.
Yeah.
So, DHS, in my experience, and the immigration court, in my experience, often will base denials on adverse credibility, and it was already kind of hard for them to be sustained in the Ninth Circuit as compared to other circuits, but now it seems even harder for them to be sustained in the Ninth.
And that's the case where Kumar, where it was an Indian person that was part of a political party or something like that, and he couldn't go back.
Yeah, no, I liked that too. He was part of one of the lower castes, and
Yeah,
no expert on
that's
castes.
interesting. Yeah, I saw a synopsis of that. It's very interesting, and the way they kind of called the judge out for kind of jumping in and making determinations that weren't fully called for, something like that. Remember?
Yeah, no, and I was gonna say I like how the political party he joined was apparently a political party that was against the caste system, which I can really appreciate. If I was part of a lower caste, I'd probably want to change the system too. But yeah, no, and the IJ and the BIA here did something that does happen often. For example, one of the reasons was that Mr. Kumar submitted a letter to corroborate his claim, and the IJ said, well, this letter only talks about 3 of the incidents of harm and not 4. But every piece of evidence doesn't need to corroborate every single aspect of a claim. I mean, it's all together. Many things happen in a person's life, and it frustrates me a lot when those type of things happen because it's not how the world works, and everybody knows it.
Yeah, like they want declarations that are like perfectly written, and that comes fake itself when you're sitting there like it's
right.
That doesn't seem reasonable.
Right, and so if you're submitting a letter, yeah. So anyway, the Ninth Circuit did affirm what I just said, essentially that that's not so reasonable there. But yeah, but if I'm being honest, like there wasn't anything completely blatant with the IJ and the BIA's adverse credibility finding. There was nothing like blatantly wrong, blatantly terrible that the IJ and the BIA did. And yet it still gets remanded under this totality of circumstances analysis. And that's because of Alam v. Garland, the en banc decision from a couple months ago. And so big things in the Ninth Circuit, challenging adverse credibility.
Big time. Well, very neat. Thanks for sharing that.
Yeah. And that would apply to USCIS as well. I mean, they make adverse cred too. If you're challenging them in the APA, in a district court action, I don't see why that wouldn't also apply. So sticking with asylum, because there was a lot of asylum over the last month, is this decision out of the 11th Circuit called Jathursan v. U.S. Attorney General. That was on November 17th. And this is a Sri Lankan case. And for some reason, it seems the 11th Circuit has been publishing a lot of Sri Lankan asylum cases in a variety of contexts. And it's, it's a pretty standard fact pattern for Sri Lanka asylum seekers. The guy was, he's an ethnic Tamil. And maybe he was part of the Tamil Tigers, but probably not. But he was certainly believed to have been a supporter of them by the majority ethnicity in Sri Lanka. And so that is often what these Tamil-based asylum claims are after the Civil War ended. And A lot of what the IJ and the BIA denied was affirmed, but the 11th Circuit's, and this is the 11th Circuit, it's not, there aren't that many reversals of asylum in published decision in the 11th Circuit, I'll put it
Yeah.
that way. But the 11th Circuit, as I read it, is saying and sent it back for consideration of whether Mr. Jathursan warranted asylum based on his membership in the particular social group of failed asylum seekers. And so that is really big to me, because that means the second the IJ denies, they've created a potentially viable particular social group. And that could be in any country. In this case, the 11th Circuit talked about news articles and other reports that indicated that failed asylum seekers are viewed by society as socially distinct and are harmed because they are believed to have said bad things about the government, for example. But that's kind of the case in a lot of countries, right? If people know what asylum is, you know that you're talking about the government. And it didn't even seem like Mr. Jathursan had that many news articles talking about what happens to failed asylum seekers. And so it seemed to me that the court was finding the particular social group viable and was just sending it back for an analysis on whether he'd be harmed on account of that. And so I don't know. That seems big to me.
Yeah.
That at a minimum, that means that practitioners maybe want to consider placing failed asylum seeker as one of their asserted grounds, just in case they do lose. And then there's automatically this group that an IJ and BIA should then consider. It's kind of circular.
Yeah.
But it's there, and it's in the 11th Circuit.
Yeah, interesting. Well, this is like these. I mean, who knows how it'll go, but it's a kind of game-changing kind of stuff potential. Like,
Right. I mean, I just put failed asylum seeker in the brief because of the decision. I don't want to be caught not doing it when the 11th Circuit says that it's viable depending on the country.
Very interesting. Well, people
And
really need to listen to this podcast. I mean, if you're doing litigation or court stuff, this is really important. Asylum.
Nah, it's yeah, I appreciate you talking about the podcast, and I don't like to toot the horn on it, but you know, I think it's good. That's why I do it. But you know, there are cases, especially in the equitable tolling context, and I've said it on the podcast. Like, so if you've been the victim of ineffective assistance of counsel, but mostly, let's talk about the Sessions v. Dimaya. That's where it always comes out. You know, the case where the Supreme Court held that Section 16B was unconstitutional, and that was half of what makes an aggravated felony crime of violence. Sessions v. Dimaya, Supreme Court says unconstitutional. Well, then you've got all these people who've been ordered deported based on a finding that their conviction was a 16B, 101A43F vis-a-vis 16B aggravated felony. And so they all want to file motions to reopen. And all of these individuals, when it gets denied, it's based on equitable tolling, saying you didn't do it soon enough after the Supreme Court issued their decision. And last month, actually, there was a Ninth Circuit case where they denied it, and I can't, the case escapes me, where the Ninth Circuit said, even if you did it soon after the Supreme Court's Dimaya decision, we issued our Dimaya decision 3 years before. And so in the Ninth Circuit, you should have brought that claim after we issued our decision, which, to be honest with you, is true.
Yeah.
And podcast is good for that. I'll tell you the change in case law the week it comes out.
Yeah.
So equitable. I mean, and that's what makes being an immigration attorney so scary as well. I mean, you've been doing. Ira Kurzban, the firm, we've got 40 years worth of clients. Longtime practitioners, all those clients, if they've been ordered deported, you got to keep up with changes in law for the rest of the existence.
Yeah.
It's on the non-citizen to hire you for a motion to reopen. But anyway, I think that's one of the good things of the podcast too, what you're saying.
Yeah, definitely.
Makes your head spin. And
that's why I touch this stuff. I'll leave this to you.
And on that, the last issue, and I don't want to talk about this all the time, but it's this never-ending thing about deficient notices to appear and the Nis Chavez and the Pereira v. Sessions, and it really just seems like it's going to be something that's going to be with us for a long time. And I think last month when you and I spoke, or maybe the month before, I talked about this Rodriguez v. Garland decision out of the Fifth Circuit, where the Fifth Circuit said, as I read it, that an in absentia motion to reopen, that is when the person doesn't show up for their hearing and then they get ordered removed because they didn't show up, if that in absentia order was premised on a deficient NTA, that is an NTA that lacked the date and time of the first hearing and the location,
Mm-hmm.
then the court has to reopen that, because the in absentia removal statute expressly incorporates the definition of a notice to appear used in Nis Chavez. And so the Fifth Circuit, where a lot of these in absentia orders happen, as I read it, was saying deficient NTA, in absentia motion to reopen, gotta grant it, gotta reopen. Doesn't matter if the non-citizen, as usually is the case, could show that they didn't receive their hearing notice or not.
Yeah.
That I don't see how Rodriguez didn't say it that expansively. And I heard from some practitioners that there were Texas judges applying it that way. Well, on December 3rd, at like 5 p.m. my time on a Friday, the Fifth Circuit issued this decision, Spagnol Bastos v. Garland, which in a footnote at the end appears to be trying to limit the Rodriguez decision that I just described significantly, saying that the Rodriguez decision only applies if the non-citizen can show that the non-citizen provided ICE with a viable address.
Yeah.
It gets complicated, it gets into the weeds, but I don't read Rodriguez as saying that. But, it's not surprising. Rodriguez seemed to be a pretty big sea change, and within a month, another Fifth Circuit panel appears to have come and said, whoa, 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 whoa. there's a little bit more to it, but
Yeah.
But I don't know. I don't. It doesn't make sense. I'm not just ragging on the panel. It doesn't make sense to me how Spagnol Bastos and Rodriguez can remain side by side. And it seems like Rodriguez is the better reading because it's based on the text of the statute and the Supreme Court's explanation of what INA Section 239A requires in Nis Chavez.
Mm-hmm.
So, in absentia motions to reopen have become a bit messier in the Fifth Circuit since we last spoke, but still better than it was 2 months ago.
Mm-hmm.
I mean, there's serious argument in the Fifth Circuit that there's certainly a basis in the Fifth Circuit for every single in absentia motion to reopen. There is a valid basis to file a motion to reopen those in absentia orders of removal if the NTA is deficient. And that, that's tens of thousands of cases since 1997. So keep up to date on what's happening with the Nis Chavez deficient NTA litigation, and it's probably gonna be around for years to come.
Yeah, this is a hot potato. It's going to be popping around everywhere. So what's going on with your December now? We're at the beginning of December recording this. I mean, you got a lot of stuff going on, but do you take a break for Christmas or Hanukkah? You're not supposed to say Christmas, holiday season.
Yeah, you could say Christmas, not me, but you can. I take a break? I mean, do any of us? I did just take a nice break for the honeymoon to go to South Africa. We did not bring back Omicron. Omicron didn't exist yet, so don't blame my wife and I. I like Thanksgiving more than the Christmas season, but I do enjoy the entire Thanksgiving to Christmas time. I mean, I work very hard, not taking so much time off, but it just feels like everything slows down a little bit, and it's nice. It's nice to slow down.
You got, because we have days off, so it's like you could plan something. I'm gonna take a little bit of break for 3-4 days, but I'll probably have my computer with me, and just in case you never know what pops up.
Yeah, it's, and a lot of it is based, at least with me, it's based on courts. I mean, for example, I have individual hearings in early and late January, early February, and early March, and so those are there, and then that affects my preparation now. That just kind of is what it is, but I am doing everything in my power to have a good work-life balance.
Well, are you still surfing in San Diego, or is it just too cold now to go?
No, I surf year-round. I water ski. So those, I do that every week, and that's important to me. And I have the luxury of not having kids.
You wear a bodysuit that keeps you warm, or is it?
Yeah, you wear a wetsuit year-round. At least I do, being from Florida.
Very cool. Well, that's awesome. I mean, if that's a good exercise to get into. I just re-upped boxing, so I'm boxing now and getting my cardio up and getting my warriorness and athletics in there.
Like a human or a bag?
Human, I got a trainer, do it twice a week, and we're getting trained to go in the gym and start punching it out, do some. I got, what is that called? I got the headgear and the low gear, all that kind of stuff. So I'm
Wow.
trying to get a little faster and better at it, and they'll start doing that. So see me in some boxing matches in the future potentially.
I
All right,
think
it's
I
just
would
fun.
I think I would just see red if I got hit in the nose or the face. Like, I don't think I would be good. I don't think I would take that very well.
Yeah. No, definitely. I've had, yeah, I'm probably not gonna go that serious. I can't risk the injury, but just as good at because you got to be really fast and pay attention. And then I'm hopefully to get back into tennis too. I haven't done that since I was a kid, but there's no tennis courts around here. I'm trying to make enough money to get a house with a tennis court. That's the goal
Oh,
in life
wow.
right now. So the
Well, you gotta
instructor's
sell a
trying
lot
to
of
do.
magazines.
Yeah, exactly. We need some more sponsors here for listening. Any Doctor wise, the price is going up.
Yeah.
So but those are like life goals. Just so I could wake up, go play tennis, teach my kids tennis, and have boxing instructor come, all that kind of stuff, and just try to enjoy life a little bit over here. Well, good to see you again. Let's see, it's early December. Probably gonna catch up in January on this stuff and go over December cases. But just enjoy your time, and for everyone's listening, we'll have a couple more podcasts this month. But happy holiday season. Hope everyone's cases are doing well, their life's going well. COVID is just like never ending. This is just like a disaster that keeps coming, but hopefully it calms down in the new year. Let's pray for that.
Happy New Year to you and happy holidays to you as well, John. Thanks for having me on, and we'll talk more cases in January.
For sure. And so hopefully we'll have you in the magazine too, in the next issue or next one after that. For listeners, Immigration Lawyers Toolbox magazines on the website. Definitely check it out. Until next time, have a good one. Bye bye.